Welcome to Frank Bruno Law. I'm Frank Bruno Law. Right to the meat, right to the question, right to the topic. Today I had a client sign a trust and related documents. A husband and wife came in and so we did a healthcare proxy, power of attorney, living will, pour over will, and an irrevocable trust. And they were there with the trustee. Question posed to me, among many other questions, right, was, should I give copies of my trust to my children? Now, it's a great question, and it's an individual answer. My response was, I have some clients that ask for several copies, and they give a copy to each child. I have other clients that don't want to give a copy to anybody, and they're not required to. While you are alive, while the trust operates as the lifetime trust for you, you are not required to give copies to beneficiaries. Upon the death of, should there become an intervening event, then you should give the trust. You should be required to give the trust to beneficiaries. Now, it's an individual choice. If you think that the plan, the giving scheme that you have, leaves someone out or slights someone, maybe you don't give it to them. However, it could be prudent to give the trust document in advance so that the children can know what to expect. But maybe not do that. How about you at least explain to the children or have a conversation with the children? I formed a trust. 90% is going to your sibling. You're only getting 10%, and that's because you're not good with money. I don't know if you want to do that. And that's a rare fact pattern, right? If you have your own rare fact pattern, reach out to me. I received a question, and here goes. I own a property inside of a revocable trust. Can I sell it? So this question is a commonly asked question, and according to the rules of New York, yes, you can sell it. Right? So this is an answer only relating to New York law. When you have a home inside of a trust, a revocable trust, the trustee, that can be the grantor, can be the person that had previously owned the home, the trustee can sell any property that's inside of the trust. Say you're selling it for $1 million. I'll make it a small number. Say the property that you have is being sold for $1 million. The payment of the $1 million will be made payable to the trust. The money will be received by the trust bank account. The trustee of the trust will deed the property out, and that'll complete the transaction. The trustee would have to get into contract, attend a closing, sign a new deed, receive the money, and the money is now inside the trust. That trust money, right, the money that had been received, may in fact purchase another property. That next property would also be inside the trust. Voila. If you have any questions about trusts, revocable trusts, maintaining trusts, the rules of the road concerning trusts, please reach out to me. I fielded a question today, and it was, a person has a deed already inside of a revocable living trust, They had obtained the trust and placed property inside of that revocable living trust a number of years ago. And now the person is considering other available options and is thinking about forming a trust for the purpose of Medicaid asset protection. So this type of trust has a few names, but basically it's an asset protection trust. Sometimes people call it a Medicaid asset protection trust. Sometimes it's just called an irrevocable trust, a revocable living trust. But the idea is the type of trust that this is, the irrevocable nature of it affords the person a level of, during their life, asset protection. So this is a person that had gotten a living trust, a revocable living trust, a number of years ago, when the circumstances in that person's life supported the decision to have that type of trust. That trust is a great vehicle to avoid probate, to pass assets on to your next of kin in a way that's quick and relatively painless, and it fit. Now, the new fit could very well be this type of irrevocable trust. The property and the assets that were placed in the revocable living trust years ago must be transferred, or at least new money or new property has to be transferred into the new irrevocable trust. That's called funding, and I think that's where I want to end today. If you need to talk about revocable trusts or irrevocable trusts, or the estate plan you had in place years ago, how we can update it, how we can modify it, how we can amend it, and how we can take the needs that you have now and put together a plan that would be well suited for you, please reach out to me. Frank Bruno Law.com.